Hello and welcome to Industry Week Production Pulse. I'm Senior Editor Laura Putre. In the past 6 months, U.S. employers have seen a lot of change in immigration policy and enforcement. Today we're here with George Perez, Global Mobility and Immigration Chair at Littler, to talk about how manufacturers can be in compliance with the law now and in the future and prepare for any unexpected visits or audits. Welcome, George. How are you?
I'm doing well. Thank you for the invite. Pleasure meeting you.
Thanks
again.
for being on here. Can you tell us a little bit about the type of immigration work that you do?
Sure. I basically exclusively represent management. I'm a corporate immigration attorney dealing with all sorts of issues for company that deals with HR issues that companies may deal with policies, visas, compliance work. I do a lot of compliance work.
So our audience is a lot of manufacturing leaders and executives, and I'm wondering what recent changes in immigration policy and law should manufacturing executives and employers be aware of?
Well, that's a good question. I mean, do you have a couple hours? Because really it is something that is on the mind of many folks, particularly in the manufacturing field. Okay, in that industry, I think we did a survey, and it's about 83% of all manufacturing responses were concerned about immigration having an actual effect on their processes. And I think if there's one area where it's going to be focused on is really compliance work. You know, whether or not the workforce may be interrupted and continue to be lawfully employed. The big issue right now for most employers across the board, including manufacturing, is not just the issue of whether or not somebody is properly documented, is whether or not they will retain that proper documentation to be able to continue to be employed, which creates all sorts of issues for clients and companies.
When you say retain, what do you mean? What are the issues around retaining their immigration status that have come up?
Well, what's going on right now is that there has been a aggressive effort by the administration to reevaluate many programs where individuals have gotten lawful status to be in the United States, whether it's the parole program for Haitians, Cubans, Nicaraguans, Venezuelans, or basically whether it's the Venezuelan TPS or Nepalese TPS or Honduran TPS. Those type of scenarios are situations where folks have had lawful status for a number of years and have now, unfortunately, as a result of the recent changes in the administration's policy, now have lost that authorization, which means the employers need to let go of that workforce.
Okay. And are there any other visa concerns in addition to TPS, would you say?
Well, I think the visa concerns dealing with maybe that part of the workforce may be visa dependent, meaning there are certain employment authorized visa statuses that allow you to work based upon sponsorship by a company. And in manufacturing, we usually see that as in the engineering, in quality control areas. In those scenarios where there is sponsorship, there may be now more restrictive review of those applications, and as a result of which could create some problems for employers in that area.
Are you seeing an increase in audits? And what can manufacturers do to prepare for that possibility?
We have, when the Trump administration first took effect in January of this year, there was a lot of talk and concern about raids, the concept of raids. And I don't use the word raid, I use the word site visits, okay? Mm-hmm. Because really it really reflects better on what's going on. And site visits basically could be one of two things. It could be an I-9 audit, which is, I think, the easy pickings and the easy way of basically doing enforcement activity because it doesn't cost the government a lot of money. An I-9 raid really involves enforcement, reviews, investigations, getting a warrant issued by a federal judge, and those take time and money and effort. Whereby an audit is you come in, you present yourselves with a 3-day notice, you come back, and depending whether you come back in 3 days or a little bit longer, depending on what's been negotiated with the special agent in charge of the investigation, you basically then deal with production of information. So we are seeing an increase in audits. I think that one of the key things that's going on is that the $165 billion as was issued to DHS, which is one of the more heavily funded agencies now in the federal government, about a little bit over 150 billion almost is going to be exclusively related to immigration enforcement. About 30 billion is immigration enforcement, 45 billion is going to be for detention facilities.
Okay. So you're expecting an increase in audits. Are you seeing that already?
We are seeing that already. We already started seeing it within the first 3 months, not in the huge volumes of 12 to 15,000 were in the pre-COVID years of the Trump 1 administration, which obviously got truncated by the scenario of COVID, unfortunately. But from a practical perspective, what we see right now is that we're going to see more that money, those $30 billion in enforcement activity is going to be spent. Among the spending approvals were 10,000 new ICE agents to be able to deal with ICE audits and ICE raids. So yes, we are expecting that. Right now we have a bit of a lull because the budget just got approved. The funding is getting allocated. I think that by the end of the third quarter, if not the first part of the fourth quarter of this year, we're going to start seeing more activity.
Okay. Do you usually hear from employers like when they're do they call you when they've been told they're going to be audited, or are they planning far ahead for these audits? And I guess I'd like to know either way what's involved, like what's involved to be prepared ahead of time and what's involved if you have these 3 days to get ready.
Right. I mean, the most productive mechanism that I can advise companies to basically consider is to do a self-audit. You might want to consider that self-audit through outside counsel to protect the privilege, or internal counsel if you have internal counsel that you work with, so that at least you can argue that you can protect the privilege, the information that you're retrieving. But you want to basically go through the mechanism of an internal audit in advance, because I get multiple calls. I get the internal audit. I want to do something on my own rather than scramble because I've got now an ICE audit on my own and I've got to respond to ICE. So from that practical perspective, we do expect that consideration is where folks now start looking at basic concepts as, by the way, where are my I-9s? It sounds silly, but you'd be shocked at how many people think they knew where they were, but when they went to look for them, they realized they weren't where they thought they were. And when you're dealing with a 3-day audit review, that becomes a big deal. So that's why being productive and proactive as to doing simple things like that and doing the audit review and remediating when you can is extremely helpful.
How often should employers be reviewing their employees' immigration status?
That's a good question. I've always opined that it might be a good idea to do it on an annual basis. But no, I'm not saying do your entire workforce on an annual basis, but do some sort of systemic spot audits, a certain small percentage. And then if you find that there's some error rates that are occurring, maybe expand that review. But at least that gets you to show, 1, due diligence, 2, capture any errors that have occurred, and 3, it actually works well from a remediation perspective, because if you do get an ICE audit by the government, they will basically then consider it a positive that you've tried to do the best you can. It's an ameliorating effect.
What about like E-Verify? If you run an employee's immigration information through that database, are you good?
Well, E-Verify is not a safe harbor provision, so it doesn't mean that, hey, you're an E-Verify employer, you get a pass and you're not going to get, negatively affected. But E-Verify does now capture alerts that are being updated by the government, where both basically if somebody's immigration status has been revoked, meaning their employment authorized status, that those alerts would appear in the E-Verify system. which then creates a burden on an E-Verify employer to make sure that they check the system on a systemic basis to be able to react and address those issues. Because then you may have issues of constructive notice, which are legal concepts, which is you should have known better and address the issue on a timely basis.
Can you explain a little bit about like the different types of work visas and like what the differences are?
Well, that's a big question, because that's like saying I want to win $1 million. How do I do that? But there are certain visa categories, or kind of what are called non-immigrant visas, which are your short-term temporary visas that allow you to work and live in the United States pursuant to a sponsorship by company. And then there are immigrant visas, which is basically green card processing, where a company can sponsor somebody by basically testing the market to determine if they're qualified U.S. workers that are willing and capable of doing the job. Because if they can, then you can't sponsor somebody that's a foreign worker. But there are visas. The most common short-term visa category that we see is the H visa for professional workers, IT workers, professionals in the sciences, professionals in business, etc. Any position that requires a degree as a minimum entry-level requirement would be fall into the H visa. Then there are categories such as O for extraordinary ability, L intercompany transfers, E for companies that are foreign-based that have treaties with the United States. So there's a multitude of visa categories and a lot of options, but it's very specific to the individual.
What about, are you seeing a lot of like professionals coming in on these like visitor visas, these temporary visas, and then, is that an issue?
Now, the majority of workers are basically sponsored because they already are here working for another employer, and they are now a candidate for new employment with a transition application to a new company, or they may be abroad living and working and basically have responded to advertisements, and they ended up in being selected as among the candidates for employment. There are folks that may come in for temporary basis, but that's not really those are just individuals that are coming in for business meetings or conferences or things along those lines that are more in line with not working. There really are just innocuous, inconsequential business type meetings. Like if I go to Europe and I meet with a client for 2 days, that's about what that would be.
Okay. What do you see like, in the past 6 months, just the most, the biggest concern or issue that employers are coming to talk to you about right now?
The biggest concern is really the effect that the enforcement activity has had on the workforce. I've got immediate needs. I'm a cooperative. I mean, my clients all cooperate with the federal system. They don't hire illegal workers intentionally. I mean, they're trying to do the right thing, but they're saying, well, they're enforcing the immigration laws. That's fine. The government has the right to do that. But the problem is I'm not giving a mechanism to basically be able to fill my needs for the workforce. And that's creating a problem. So there's a real concern, particularly in the small to mid-sized employers, of how they basically are going to address the staffing shortage as a result of the increased enforcement activity. Go ahead.
So you've seen clients have to let people go because,
absolutely.
Yeah.
They have unfortunately no choice. If somebody is determined to be undocumented, or somebody is determined to have lost their lawful status and they are no longer employment authorized, there is no choice from an employer but to let go of that talent.
And are more of the technicalities being enforced now that maybe before it was just?
They are very strict in the reference to make sure that the I's are dotted and the T's are crossed, to make sure that basically everybody is compliant with what the law requires. I am seeing an environment of greater scrutiny of applications for individuals that are applying for visas that support their status, or greater scrutiny of an individual status after they've gotten approved. I see that. I've seen an increase right now. The government's announcing a denaturalization process where even if you're a U.S. citizen, You could lose your U.S. citizenship status if there was a misrepresentation made at the time of original application. So a
Okay.
lot of that vetting is going on right now.
Is there any kind of a quick fix, or maybe not a quick fix, but a longer fix that could remedy some of these problems that employers are having?
Now you're asking me to get on my immigration attorney bandwagon.
Yeah.
I'll give you my personal view on that. There is, I've been practicing for 40 years. I'm board certified by the state of Florida in immigration nationality law. So I've been doing this exclusively for a very long time, and this has been my primary area. Ever since I started, the one thing that the politicians, I'm not making a political statement, I'm just making a practical statement
Right.
on behalf of corporate companies. But bottom line is what's going on is that the focus hasn't been on, what is the comprehensive immigration reform that should be going on. Let's do enforcement. Let's do what the law requires us to do. But also let's create mechanisms that allows U.S. employers to legally bring in the talent when that talent is not able to be found in the United States. That, I think, is a combination of both. That's what really needs to occur, but I don't think that currently right now there's a view that that's really the direction that the administration prefers to go.
Okay. So just I wanted to touch on those site visits a little bit.
Yeah.
What can manufacturers do to be prepared, whether it's a planned visit or if immigration enforcement ends up at their door?
Well, we talked about it a little bit, Laura, and that is basically that, one of the things that you would positively and proactively want to do is do an I-9 audit, because that lets you make sure that you've captured everybody. Did you, you're supposed to review the I-9s and make sure that you have a tickler system, so if somebody's expiring or their lawful status, that you vet it and review it before it expires so that they can continue to be employed. So that spot audit lets you figure out and make sure you didn't miss anybody, make sure you didn't, create the system wasn't as viable as you thought it was, but it lets you make those fixes. And if the talent can stay because they have lawful status, you can resolve that. If the talent for some reason can't, because they can't overcome it, then you have to let them go, but you rather deal with that on your own terms, meaning you let them go and then try to find a replacement rather than scrambling, find out that the government's telling you that you have to let them go immediately. When the government's looking at it, it may be a scenario where we're thinking it may be more they're going to come pick them up, whether it's at the work site or at home, compared to in your case, you would tell them, I can't employ you anymore, but then you find the talent otherwise somewhere else.
With the ICE or an immigration enforcement visit itself, what if they want to come in and inspect the entire plant? Like, are there areas that they can't go if you have proprietary areas?
Good question. Absolutely, there's two types of audits or site visits that can occur. There is the one site visit that administrative warrants are issued, or basically an I-9 inspection. Those are areas where if there's administrative warrant issued, that's an administrative warrant is one signed off by a supervisory agent, not by a federal judge. Those you would need to give consent for them to enter all private areas of the company. So let's say you have a reception area that would be public, but if there is a warehouse in the back of that reception area where there's manufacturing going on, that is private, and that usually they would need consent to go on there. So the question I get normally is, what about if ICE comes and they're looking for Joe Blow and they want to basically pick them up or talk to him? What do I do? And my advice is always to basically get those individuals, remove them from the work site if they're on that shift, put them into a secure site, give them access to that secure site with the ICE agents, but not walk the ICE agents through the backroom operations that are private, because then you're giving them consent to talk to anybody or view any information that they retrieve by going through the premises there. If it's if it's a judicial warrant that they do not need consent, then they can enter public and private areas depending on what the warrant says.
Okay. And should you be saying anything to your employees in advance, just like about immigration enforcement? possibly coming to
I'm
the
very wary of basically giving proactive advice from an employer because that one alludes to that maybe you think that they might have a questionable status, and then that could call into the concept of whether there was actual or constructive knowledge of their being unlawfully in the country. So, I mean, if you want to give them some sort of viable access to counsel on their own, where basically you could create immigration benefits or give them access to an attorney to deal with real estate closings or mortgage or wills or immigration issues, but you give them the option of what their issues are, then you can let them find that advice on their own. But I don't think it's a good idea for a company to be able to give that proactive advice, because it could create a problem for the company with exposure.
I guess I mean not tipping them off about.
Oh no, we don't definitely.
No, I don't mean that. Yeah,
Yes.
I mean like there's people gonna arrive on the site that have that are armed. Is there any sort of protocol?
Well, there is a protocol, and basically the first protocol is who to contact with if the receptionist is coming in and they're given a warrant or a subpoena to speak with a specific individual that's working that day.
Okay.
The first thing to do is create a protocol so that reception area, whether he or she is there with information as to who to contact, escalate. I don't think we should have somebody in the front desk making a determination as who has access to the premises. I think that should be somebody at upper level management, so that there should be some sort of control mechanism as to how that access is given.
Okay, well, thanks. We're just about to wrap up here. Is there anything else you wanted to add, or just remind manufacturing employers, regarding immigration?
I think immigration issues are in the forefront of most people manufacturing right now, and I think is an important aspect of it, is to basically do line reviews and create a mechanism where you can control your own destiny rather than let the destiny be controlled by a random audit by the government without you having any idea where you fall and can control the mechanisms as to how to deal with the staffing shortages that may or may not occur.
Thank you so much, George, for being here. It's been great to have your insight. It's been very helpful. So I just wanted to say, Jorge Lopez of Littler, that he was our guest today, and this is Industry Week. If you have any, this will be live on LinkedIn and also recorded and posted on our site. If you have any comments, you can go to our site or go to LinkedIn. Thanks so much for talking with us.
Welcome. Thank you very much for having me.